Welcome, and thank you again for the Society for the invitation to talk about contracts and letters of agreement. This is the third session, and we're getting a little deeper into the contracts. We've talked about the basics. We've talked about getting that executed, what the legal requirements are, what the practical requirements are, how to deal with some of these aspects. Now we're going to talk about a little deeper into it, some clauses. We're talking about, in this case, the written contract, how to protect yourself or have better assurance of getting paid or better educate the client on the surveying services that you're providing. So we're going to be talking about clauses. When I talk about these clauses, do not misunderstand me. I'm not saying you should use them or you have to use them. We're just presenting them as something to consider. It's often like family law where they say, well, you should have a prenuptial agreement. And most people don't use a prenuptial agreement, although many of those that didn't use them wish they had used them. And so on the second marriage, they are sure to use them. And that's how surveyors tend to treat these additional clauses is, oh yeah, Knut, it's nice of you to tell me about this, but I don't going to use them because I don't want my written contract to be cluttered. I don't want to have a 15-page contract. And then after they've been hammered a couple times by clients, they're saying, well, I wish I would have used that particular clause. These clauses I'm going to talk about now, I would say in many cases should not be used. Just like that prenuptial agreement, a lot of people that are thinking about getting married, if they said, Knut, should I use a prenuptial agreement? I would say, well, probably not. There's nothing to dampen that loving spirit that say, oh, by the way, honey, I'd like to marry you, but you're going to have to sign this prenuptial agreement before we get married. It's just running counter to that loving and trusting and special relationship you'd like to have with that soon-to-be spouse. And that's the same kind of look you're getting with a client when you're putting some of these clauses in a contract. Now, sophisticated client, the developer, the architect, the engineer, yeah, maybe you should consider some of these clauses. So let's look at some. And let me explain those to you. So you can see, well, maybe I should have that. Maybe I shouldn't, or maybe I should use this particular clause with this type of client. And that first clause that you see there is what's known as the indemnification clause. An indemnification clause, let's just talk about that one word. Indemnification means that you will cover some other person's loss. Not you in particular, you the surveyor, but that person that's signing the contract will agree to cover some other person's loss. We all have indemnification clauses. I'm pretty confident in saying we all, but there may be a couple of you listening to me that don't. But if you have automobile insurance, you have an indemnification from the insurance company. They've indemnified you. They've said if you get into an auto accident where you're damaged, we will pay you up to a certain amount. We had nothing to do with the automobile accident. We weren't driving. We didn't tell you to buy that particular type of car. We didn't tell you how to drive, but nevertheless, we will indemnify you. We will cover your losses. We will make you whole up to the amount stated in this indemnification contract. You can use that same concept in your contract, where your client will indemnify you if you suffer losses as a result of the services you provided to that client and are being sued and found liable from some other party. Such as the neighbor. Maybe you're working for the architect and you provide a plan for the architect and you have an indemnification clause with the architect, and the landowner, who the architect was working for, sues you. And because of your indemnification clause, you can look to the architect and say, I'm being sued by your client, architect. And according to this contract, you've agreed to indemnify me in this case. So let's look at that example clause there. And I'm not saying that this is ideal for you or even for the state you're practicing in, because some states do have laws that deal with indemnification of professional services. In the event of the judgment or settlement with a third party, that would be you having a judgment against you, the surveyor, by a third party, where the practitioner, that being you, the surveyor, is judge or assume liability for work performed on behalf of the client shall reimburse you for all reasonable costs and damages, including litigation costs and attorney's fees. Now, that's a hard one, I understand. If you're thinking about that, you just listen to me read that clause, so you say, man, how am I going to get this client to sign that? Why would any client sign that? The client will sign that if you tell the client, let me give you an example. Let's say the client is wanting to do a timber harvest. They got some woodland, they want to do a timber harvest, and they want to get the boundary, approximate boundary location through that timberland so that the harvester won't cross the boundary. And they don't want a full boundary survey, and you're willing to do it. Let's just say that. Now, I know some of you listening to me say, I'm not going to do that. I won't do it. But other ones will say, yeah, I've done that. I could do that. I get out there with my GPS. I can find enough evidence so I can locate that boundary within 5 or 10 feet. That's not hard. It's down to the nearest foot. That's hard. That's going to take some work to get that boundary down to the nearest foot or less. But if all my client wants is the nearest 10 feet, and they're agreeing to keep the harvester away 10 feet from my marked line, hey, I'm in good shape. I'll do it. And I'm not going to sit here and say that's a good idea or bad. I'm just saying this is what you've agreed to do. And the client's happy because they're getting their boundaries roughed in for considerably less. But you've warned the client. You said, listen, this is what I'm going to do for you, but it's not going to be certain. Oh, yeah, that's fine. That's all I want. That's good. Just a couple $100 survey. I don't need the $5,000 survey of my boundaries, a couple $100. That's great. And this is where the surveyors say, however, you need to indemnify me. If it's not good, and you can hear the landlord say, why should I indemnify you? Because after you harvest the timber, for example, and you sell this property, and the person says, where's my boundaries? I don't want you pointing to that line of fluorescent orange ribbon hanging and say, There's the boundary. I had a surveyor mark that for me. I want you to be able to say, ooh, I better not say that. I better say, well, that's the approximate boundary. Because if I say that's the boundary, and that person goes and builds right up to that, or maybe the neighbor does, builds right up to your, and crosses the boundary, and then sues you because your client failed to tell them that you're only doing approximate location. That's when you want to be able to go back to the client and say, you know what? You've got to indemnify me for the cost. I did this on your behalf, and you agreed that you're going to take the risk, not me. You're going to take the risk of me doing it according to what you wanted or needed. So that would be a case of indemnification clause. It'd be great if you could put it in every contract, wouldn't it? Wouldn't it be great if you could get this in every contract? So if you're sued by any third party, you can point to that and say, client, you got to cover me. You got to pay my attorney's fees. I think it'd be great. I mean, go ahead and try it. I just don't think it's reasonable in most cases to use this clause, but you can see we've all done surveying services where we have seen a risk, but we've gone ahead and completed the services knowing there's a risk there. And in that case, we should always be saying, am I doing this for the client's benefit? And if so, shouldn't they be indemnifying me for the risk that I'm taking on their behalf? So if you're taking a risk in providing surveying services for the client's benefit, you should be thinking about an indemnification clause. I mean, we often have that. Whether it's some of you delineate wetlands, maybe you do on-site septic systems and you say, oh yeah, the system should work. There's always a risk. And if the client is aware of that risk and wants us to go ahead, shouldn't they indemnify us for that risk? All right, enough on indemnification. If you have questions, hey, write it down. Write it down. At the end of the session, should be some time for questions, and I'd love to have it, so write those down. An hourly rate supplement, we talked about this. Whenever you use a fixed fee, always put an hourly rate supplement, or almost always. Because you'll have the client come up and say, while you're here, would you also do this? And it's typically not you, it's your field crew. You send out there to do a real simple job, and it takes them 4 hours, and they come back and they say, oh, but yeah, the client wanted us to set the one corner pin, but then he also wanted to check and make sure that his building was off the line, and the fence he was putting up was, and you've heard this. If you practiced as long as I have, you've heard the story where the field crew comes back and they've done extra work for the client. They should have called you. It would have been nice, but on the other hand, it was smart of them to do it now rather than come back and have you send them back out again while they're there. Go ahead and do it. So here's the clause, right? For any and all work outside of the scope of the contract requested by the client, the practitioner shall be paid $100 per hour plus any costs. Now, I'm not saying you have to charge $100. I want to get in a fixed fee. I don't care if it's $40, $200, whatever. But that way, when you do the extra work, you can say, okay, it's contract. The contract's already stated how much the client's going to pay for this extra work. All right. Next clause to consider. Who owns the documents? Again, if you practice as long as I have, you don't even have to practice as long as I have. If you've practiced for probably 5 years, you've had the client that thinks they own all the information that you obtained in order to do their surveying services. They own it. You can't use it. If the neighbor calls and wants a survey, you can't do it unless you pay them back. All right. Now, I'm not saying you shouldn't keep information confidential for the client. And in those cases where ethics require you to do so, you should. I don't care who owns the documents. But you would like to make it clear that if another surveyor calls you up and they've been helpful to you and they want a copy of the survey you did for the client, then you don't have to worry about the client going ballistics thinking they own that survey and you shouldn't have given it to the other surveyor. Even if there wasn't any problems with the client's boundary survey. And again, you don't have to practice long to find the client that goes ballistic when you've given a copy of the survey you prepared for them to some other surveyor or somebody else. Well, this clause simply makes it clear that you own all the documents and information discovered or obtained during the course of surveying services. They're yours. Ethics might limit how you can use them. And if the client doesn't like it and wants to own it, well, that's a separate thing to discuss. For the right amount of money, I'm sure you would say, okay, client, you own it. For that amount of money, it's yours. I'll never use these. I'll rip up every copy I have. I'll burn it or whatever to do. For that amount of money, I'll be happy to say it's yours. But it's something to discuss. Use them as we want. We can use them if that client sells the property and the new owner calls us up and wants us to resurvey the property, we should be able to use all the deed research that we've done. Yet I'm telling you, there's people out there that would be furious that we did that on things that they've already paid us for. All right, just makes it clear. You know who's good at that? Ownership of documents, architects. They understand copyright law. They understand it. Somehow they've gotten a course on it at their architect schools, and they're very good about ownership, copyright, and so on. They know when they design a building that it belongs to them. That it doesn't belong to the client they did the design for. It belongs to them. For some reason, surveyors that think they did a subdivision plan, that somehow belongs to the client. That's not what copyright says. Copyright says you own that, surveyor. That design is yours. I don't care if you record it at the county registry or the surveyor's county surveyor. It still can't be copied. You own the copyright. Now, it can be copied under fair use and stuff. I'm not going to get into copyright law. That's another whole session by itself. But copyright, if you understand copyright law, you understand that you that created that subdivision design, if that design's yours, you own the copyright on it. You own it. Architects understand that. Surveyors don't. So ownership of documents, sometimes it's necessary. Next clause to think about is arbitration. Litigation is horribly expensive. Let me just give you an idea. I have a client that'll come to me. Like I say, I do a lot of litigation. I've done appeals and so on. They'll come to me and they'll say, Knut, I got a boundary dispute. You're the person I was told to come to. You do a lot of this area. I said, okay. And then they'll tell me what the dispute is. And I'll say, I'm going to tell you something. I want you to think about this. I have yet to litigate a boundary for less than $40,000. It's more like $60,000 to $80,000. I don't care. I don't care if it's a foot. I don't care if it's 10 feet. Litigation is expensive. Takes years to get through a court. And I tell a client right up front, is that worth $40,000? If not, don't bother. There's a rule. I just told somebody yesterday over the phone. They kept saying, but I know I'm right. I said, I don't care if you're right. Being real tactful. You know, when you get old, some of you that are listening to me know this. When you get old, you realize you don't need to be as tactful as you were when you were young because you really don't care. Right? So I tell a client, I said, I'm going to tell you an ultimate truth. You get as much justice as you can afford. And listening to you leaves me with a definite and firm impression that you can't afford much justice. So don't bother. Now, some of you are curious, okay, what was this client? Like I said, just yesterday, client was calling, their mother owns 80 acres of land and they think somebody's harvesting over the boundary and geez, wouldn't this be interesting? And yes, you're the expert. You could go up there. You've done this kind of stuff. And would you do it? Yeah, sure I could do it. Think 40,000, but that's a lot of money. Yes, but that's what it's going to cost. But I don't have that kind of money. Well, then you don't want to start the litigation. I don't know what to say to you, client. If you want free legal representation, go out and shoot the neighbor. Then you'll get free legal representation. That's the only time you're guaranteed free legal representation if you're poor is if you commit a crime. You're not guaranteed free legal representation in a civil lawsuit. If you don't have the money, then don't do litigation. I'm sorry, that's just how it is, right? Every kid in America would probably want to go to some expensive Ivy League college if they could. You just don't have the money. So, you know, there's nothing wrong with a state college. I mean, our whole life, as we've aged, we realize money does matter. You don't always get to do stuff. If you don't, you might want to, you might think it's your right, but you don't get it unless you have the money. Well, that's litigation. And as a surveyor, and we're thinking about, oh my gosh, if this client breaches my contract, is it worth suing the client? And many of you listening to me have had contracts that the clients breached and we did not sue them because we knew it was not going to be worth the hassle. We're willing to write off that because we know that litigation is going to be more expensive. Well, this is an option that we can go to arbitration. Arbitration can be done in a matter of days at far less cost than litigation. So here's the clause, right? In the event of a dispute for fees exceeding the small claims court, because it's hard to beat small claims court, I'll tell you. I mean, that's a nice court. All right, exceeding the small claims court amount or in other matters, either party may request arbitration. Upon written request, the parties will enter into binding arbitration according to, and you can put in state arbitration laws, or you can even put your own. Arbitration, you can make your own laws. I've been an arbitrator numerous times. I've been called to be an arbitrator, and within the end of the week, we've got it settled. And the parties are I won't say happy, because there's usually one person that's happy and one that's not. But I mean, for under $2,000. we've gotten that boundary dispute settled. The trouble is you need both parties to agree to arbitration. So a boundary dispute is not usually arbitrated until both parties have spent thousands and thousands of dollars in litigation, said enough. Let's go to arbitration. But you can agree to arbitration, obviously, after the dispute, but you can also agree to it before a dispute, and that's what this clause does. So if you have a dispute with your client over fee, which is under the small claim or over the small claims, you don't have to hire a lawyer. You just give them written notice and say, we're going to arbitration. Let's go agree on an arbitrator. An arbitrator can be anybody. Doesn't have to be a lawyer. It could be a surveyor. It could be a lay person, whoever you can agree upon. Now, sometimes state arbitration laws say, here's how it's done. If you can't agree, list of names, one party, the other party picks one from it, and that's the person, and off you go. You split the fees of the arbitrator, and that's Judge Judy and Wapner's court. They treat like they're judges, but they're really arbitrators. They probably aren't real life judges appointed by a municipality or the state. They're probably once were judges, but they're arbitrators. Those two people that are arguing before Judge Judy have agreed that whatever Judge Judy says, that's it. Judge Judy is an arbitrator. You can make anybody an arbitrator. Anybody you can agree on. So anyway, I ought to tell you one quick story, at least I hope it's quick, about an arbitration I did, just to tie in the cost of litigation and arbitration. But I got a call from an attorney, said, Knut, would you be an arbitrator? Yes. Remember, I just said to you that you can set your own rules of arbitration. An attorney said, well, what we want you to do is look at a decision that the court just gave to the parties, determining the location of a boundary. And we both sides looked at this agreement, and we both, or decision, and we both thought we won. In other words, the judge's decision was so unclear, they didn't know what the judge had decided. Now, it had taken them 8 years of litigation to get to this point. After the trial, they had to wait a whole year for the judge's decision to come out. They'd each spent well over $40,000, $50,000 in litigation, and they finally get the results, and they don't understand them. And so the attorney calls me up and says, Knut, your arbitration law is that you don't get to decide if the judge is right or wrong. All we want you to do is look at this agreement, listen to both surveyors, explain why they think they won, and then tell us what you believe the judge's decision was. So, okay, you've told me what law I'm bound by as an arbitrator. I don't decide if the judge is right or wrong, just what the judge decided. We agreed on a fee. 2 days later, we met in the attorney's office. Both attorneys were there, and the surveyors each explained why they think, according to the wording in the decision, that their boundary was the correct one. According to the law that I was operating under, that the attorneys had set for me, I had to decide within 2 days. End of the week, I told them what the judge meant by the judge's decision. It was done. That's arbitration. All right, enough. Limitation of damages. We all make mistakes. So I tell students, I say, listen, you got your results back on the exams. Some of you made stupid mistakes. I'm going to tell you something right now. Just because you get a diploma in your hand and you go out there and work, you think because of that diploma, you're not going to make any mistakes in real life. You're foolish. I make mistakes. Weekly, I make mistakes. Now, they don't necessarily result in damages. But for example, I might have failed to tell my wife after she came back from getting her hair cut how beautiful her hair looks. That's a mistake. Can we all agree there, all the men that are listening to me and some of the women, that was probably a mistake on my part? Right? We make mistakes. That was just a personal mistake, but we make them in business. We make negligent mistakes out there. Many times we go out there, fix them up. It costs a little money, but we aren't getting sued for millions of dollars, but we make mistakes. We're going to make mistakes till the day we're in the grave out there. What we'd like to do is not have the client listening to some advertisement on TV or radio where some law firm says, have you been injured? Call the law offices of, so-and-so. And some clients looking at, this pin out there that they think's wrong, and they're calling this law firm. And the next thing you know, the law firm's suing us for like $1 million for mental, problems with a client, and $50,000 for this and that. I mean, holy smokes. So why not put a limitation of damages in our contract where the client agrees that should we have made a mistake or they have cause to sue us, that their damages are limited to a certain amount. Well, let me read the clause, the sample clause. The practitioner's damage to the client for any and all claims shall not exceed the fee received for surveying services on behalf of the client or $10,000, whichever is greater. Now, how do you figure this fee? Well, a lot of times the amount of fee, right? Basically, you've just done the survey for free for the client if you did it incorrectly. A more appropriate amount is the amount of your insurance coverage. So if you have a $200,000 limit on your errors and omissions insurance, well, that's the amount of fee you put there. You have insurance, but there's a cap on your insurance. If there's a $200,000 cap on your errors and omissions insurance, you start to have some bad days when you get sued for $1 million. Because in that case, the insurance company is likely just to write a check out to the plaintiff and say, here's $200,000. We'll see you, surveyor. You've just exceeded our coverage. We've paid the $200,000. The other $800,000 on the $1 million claim is up to you. And you like to be able to point to that clause and say, if it's above my insurance cap, I don't have to worry about it. So some realistic amount, or as the clause there shows, it's a combination of two or more, depending on the situation. Now, an important point with the limitation of damages. This limitation of damages, and in fact, many of these clauses that we've talked about only apply if there's litigation with the client. So if the neighbor sues you, if you have a limitation of damage clause with the client, in the contract with the client, for let's say $10,000, and the neighbor sues you for $50,000, that clause doesn't mean diddly. It's only the client that's agreed not to sue you for more than $10,000. Any party that didn't sign that contract's not bound by that limitation. So if the neighbor wants to sue you for $50,000, that limitation of damage clause doesn't do any good. Now, an indemnification clause, the first clause we talked about, that might help you. Because now you can go to the client and say, according to our contract, neighbor's suing me, you've agreed to indemnify me if this happens. So looks like you're going to be sending me some money for legal costs. So a limitation of damages and an indemnification clause will sort of protect you from any direction. But just a limitation of damage clause or the arbitration or any of those other clauses are only between you and the client, only the people that have signed that contract with you. Limitation of remedies. Similar to limitation of damages, except now your client's agreeing to limit certain aspects of the litigation, not the fee, but aspects. So looking at that example clause, right? Any and all claims shall be made within 1 year and not later of the act complained of, regardless of the time when the act was discovered. So some of you might say, well, what's that mean? Almost all states have what's called a statute of limitation. A statute of limitation, and most of you are familiar with the statute of limitations for ownership of property, which is part of adverse possession, right? You have to occupy somebody's property for that statute of limitations period in order for you to acquire title by adverse possession. Well, there's statute of limitations for anything. I mean, if you got your little smartphone there and you're listening to me, just put statute of limitations for Illinois and you'll see all kinds of statute of limitations for criminal acts, for civil, different types of civil acts, statute of limitations for breach of contract, well, you're looking for statute of limitations for negligence. It's typically 6 years. Most states, it's 6 years. I don't know what it is for your state. Let's be honest here. So if you got your phone out, you're doing that search on your phone on statute of limitations for negligence in Illinois, you might get a hit. And you can bring that up at the end of this session and say, here's what I found. And that would be probably useful information. It'd be great for me because I think, whoa, there's one person actually listened to me and wasn't, drinking their beer and, in La La Land while I'm talking, right? So there's at least one person at the end of this 3 hours that's saying, yes, I'm still listening to Canute, right? So that would be interesting on my part. But for the rest, say, well, I know what the statute of limitations is, but here's the problem. Attorneys have found a way around the statute that's meant to protect. And they found a way around by saying it's a discovery, by convincing the court, the high court in the state to say, well, the statute doesn't run until the client discovers the area, or error, I should say, or the negligence. So that's fine. You did a survey 20 years ago when you made a mistake and you think, oh boy, many don't even know about the mistake, but it was 20 years ago. That landowner finally discovers it 2 days ago and they sue you and you're thinking, oh my gosh, that's back before computers. I don't even know if I have the records. How am I going to defend myself? You're thinking, what happened to 6 year statute of limitation? Well, the 6 years starts when that landowner discovers it, if the discovery rule is in effect. It reminds me the case of Rosny versus Burnell. It just popped in my head, is an Illinois case. It's the first case where the tortious action of negligent misrepresentation was created. And it came out of Illinois. If you look up Rosny versus Murnell, and it was against a surveyor. Isn't that something, how surveyors are famous across the nation? Probably all 50 states have cited Rosny versus Murnell, an Illinois case that created the tort against surveyors of negligent misrepresentation. Boy, there's something to live with. Some of you listening to me may know the surveyor, Murnell. So yeah, I remember him. Probably dead by now. It's quite a long time ago. I think well over 50 years ago when this case first created it. But anyway, how I pulled that out of my head. But anyway, the problem was in that case, and it would have been nice if the surveyor had a 1-year statute of limitations that they created by contract. Although I don't think it would have helped because I think it was a subsequent owner of the property that surveyed. Like I say, these clauses don't protect the surveyor if somebody other than the client wants to sue the surveyor. All right, so we talked about the statute of limitations, and so what you're trying to do is knock it back. Do two things with this clause. Number one is reduce it from the statute amount down, and also get rid of that discovery rule. Now, you can also use it to deny certain claims. You could say you can't sue me for breach of contract, or you can't sue me for negligent misrepresentation, or you can't sue me for negligence, but I mean, you can form and eliminate certain remedies from any potential lawsuit against you as a surveyor. All right, enough on that clause. Big one that you've heard me talk about all through this presentation. It's attorney's fees. You can win the battle and lose the war. How many times have I had clients or people I know that litigated their case, won the case, but were paid less than what they had to pay their attorney to win the case? Let's go back to that example where I tell a prospective client that litigation is going to cost $40,000. If I hadn't told the client that, and it's a 1-foot boundary dispute, and at the end the client wins, the court determines that they own that 1-foot disputed strip, but they paid me and others $40,000 in legal fees. You think that's a win? Do you think that client's sitting in bed at night and say, yeah, golly, I won that? The clients, landowners I know that say, I'm never going to sue again. Reminds me of Ben Franklin's statement. This is attributed to Ben Franklin. Ben Franklin said, I only lost 2 substantial sums of money in my lifetime. Once when I lost a lawsuit, and the second time when I won a lawsuit. So if you could put in your contract a clause, like I've shown here, let's read it. In the event of litigation, the party losing the litigation shall compensate the winner for any and all reasonable attorney's fees and court costs, provided, however, that where the losing party has made an unconditional written offer of settlement within 3 weeks after the completion of discovery and the damages awarded do not exceed the amount, the losing party will not be responsible for attorney's fees and court costs. So let me explain that clause, but let's go the broad thing. So basically you're saying, look, if you lose, you pay the winner. Most people that I talk to, landowners, think that's how it is. No, this is America. It's called the American rule, in fact, because we're the only Western civilized country that has this rule. Most other places, if you lose the lawsuit, you have to pay the other side's attorney's fees in addition to the damages, but not in America. Oh, no. In America, each side's responsible for their own attorney's fees, whether they win, lose, or whatever. That's to make sure we have lots of litigation to keep attorneys gainfully employed. All right, that's a little bias on my part, I'll admit. All right. You can change the American rule by contract. Like that contract there. Now, if you're going to look at this, let me add one thing. I'd say the party, in the event of litigation, the party substantially losing the litigation. Fairly recently, I've been involved where this fee is, and the party's trying to argue because they won some small point of the litigation, that since they didn't lose all of it, they're not responsible for paying the other side's attorney's fees. So stick substantially losing, so that just because you won some small minor point in the litigation, that doesn't relieve you of, because you're the substantially losing party, of paying the winner's litigation fees. That clause in of itself will stop a lot of clients from suing you knowing that you're going to settle with them. Because you're thinking, why do I want to settle? You're going to be responsible for my litigation fees. Now, a couple other points with this clause is you're only going to get reasonable attorney's fees. So don't go out and hire a $500 an hour lawyer from some big firm, because that's not reasonable attorney's fees. You can go ahead and hire them, but the court's only going to award you what's reasonable. So if the typical lawyer in the area is only charging $200 an hour, you're going to be on the hook for the other $300 an hour that this big high-priced lawyer that you hired is charging you. All right, the other part of this clause is that you want to encourage settlement. So what you'd like to do is say, all right, client, if you're willing to pay me a reasonable fee, or let's say that you're on the hook because this clause applies to both parties to the contract. Let's say you made a negligent mistake and they're suing you, and you say, oh boy, I don't want to have to pay for the other side's legal fees, so I'll make a reasonable settlement offer. What you don't want the other side to do is say, I'm going to refuse your reasonable settlement offer because I'm going to chance going to court, spending an extra $30,000 in litigation fees on the hopes that you're going to be on the hook for even more. What this would do is, if you made a reasonable settlement offer, they refuse it, you go to the court, and the court says, you know what? The judgment is the same or less than what the settlement offer was. You're off the hook for attorney's fees. Last clause. And of course, we're running out of time as well. So right on schedule. You want payment terms there that will encourage you, the client, to pay you sooner rather than later. You don't want the client looking at their, MasterCard bill, looking at your bill and saying, well, the MasterCard's charging 18% interest. I better pay them. The surveyor's not charging me any interest. I'll just put them off for another couple of weeks. All right. You want that that client to say, I better pay them sooner rather than later. So here's the clause, right? The client is responsible for payment of services rendered under this agreement. Bills may be rendered as work progresses. Final payment for services will be made before any signed and sealed plans are released to the client. That's a stick approach. You don't get the plans until you pay me in full. You can give me the check, I'll give you the plans. You don't give me the check, you don't get the plans. If you need more time to pay me, then you're going to wait for that extra time before you get the plans. This really works good for developers, right? They need the plans, but they don't want to pay you. You want the plans, you got to pay me. So that's a stick approach. Payment is due and payable within 10 days of the date of the bills. A light charge of 1.5% per month will be made on all bills not paid in 10 days. Again, more sticks, right? You owe me interest. Most surveyors, by the way, are willing to forego the interest just to get the payment. But it's good to be able to point to that and say, if we're going to court, small claims court, I'm going to tack this on. All right. In the event that any portion of the bill remains unpaid for a period of 60 days, the client shall pay all costs of collection, including additional time required and any legal processing and lien fees. Again, you pile on the sticks. So what's a carrot? Well, a carrot would be if the client pays within 10 days, the fee will be reduced by 1%. Some of you have probably gotten bills from your fuel oil heating place that says if you pay within 5 days, this bill will be reduced by 1% or something like that. That's a carrot approach, right? That's a carrot approach. You pay me in cash, you get a reduction. You pay me within a certain time, you get a reduction, right? That's using the carrot approach. All right, I see there's only a couple minutes left, and this is a time